Good afternoon, everyone. My name is Max Latona. I'm the Executive Director for the Center for Ethics and Society at Saint Anselm College. It's my pleasure to welcome all of you here today on behalf of the Center, but also the Institute for Saint Anselm Studies and the New Hampshire Institute of Politics to this event. I can see we have a wonderful mix of students and faculty colleagues and members of the administration and the monastic community, and some members of the public. So wonderful. Thank you all for coming today. So today's event is either a beautiful example of serendipity or a case study of abject miscommunication amongst departments at the same college. I prefer to think it's the former. Allow me to explain. Today, February 22nd, 2023 at 4:00 p.m., we had two events scheduled on campus in two separate locations, but on roughly the same topic, the Supreme Court and modern politics. One program with its own illustrious expert in constitutional law in the Supreme Court was to be held by the Center for Ethics and Society at 4:00. By the Center for Ethics and Society and the Institute for Saint Anselm Studies at 4:00 in the Malucci Theater. The other program with its own distinguished jurists and exceptional experts on constitutional law and politics was to be held at 4:00 here at the New Hampshire Institute of Politics. So only very recently, and by that I mean in the last 48 hours, did this come to our attention, and the organizers of these respective programs huddled together and decided that in the interest of furthering dialogue, collaboration, and the common good, not to mention resolving a ridiculous dilemma for most of you as to which event to attend, that we would combine the events while trying to preserve the distinctive attractions of each. The result is what we think will be a wonderful program in store for you today, one that brings together experts in constitutional law and political science, as well as a highly respected jurist to discuss the Supreme Court and its role in our modern political environment. So the title of our now revised program is the following: The Supreme Court in the Modern Republic, Religious Liberty and Other Issues. Now, before I say anything more, I just want to thank my colleagues, Jen Lucas, Montague Brown, and Ann Kamen for being so flexible and helping to make this happen. I also want to thank our speakers, moderators, and panelists for so graciously adapting their plans and even their remarks to accommodate what was a very last-minute change of format. So here's what you can expect today. We'll begin with about a 20-minute presentation on the Supreme Court's treatment of religious liberty and the First Amendment, and then follow that up with a moderated panel discussion of 30 to 40 minutes that will address such topics as the changing role of the justices, the role of the Supreme Court in recent elections, and more. We will then have 15 to 20 minutes or so of time for Q&A, and we'll be sure to start with an opportunity for students here to ask questions. And then we'll wrap up at about 5:15. So before we introduce the speakers, I'd just like to note again that this event is quite possibly actually the first collaboration among three important centers here at the college. The first, it wasn't a great collaboration either, but it will be. The first probably needs no introduction to you. It's the New Hampshire Institute of Politics, and it has for its stated mission to educate, engage, and empower citizens to participate in the civic and political life of their local, national, and global communities. I think understanding the Supreme Court of the United States and how it is involved in protecting our Constitution and ensuring equal justice under the law is core to the mission of the Institute. The second center is the Center for Ethics and Society, whose mission is to use research, education, dialogue, and collaboration to address important issues facing our communities in New Hampshire. And one of these important issues is our rights and freedoms, including freedom of religion. And today we'll hear a little about how the court has tried, whether successfully or not, to both protect religious liberty, but also to maintain the separation of church and state. And then to say a few words about the third and final center involved, as well as to introduce our speakers for today, I'm going to now invite my friend and colleague Montague Brown, a member of the philosophy department, to the podium. So please welcome Professor Brown.
Thank you very much. Yes, the Institute for Saint Anselm Studies has a couple of two-pronged mission. One is to promote scholarship on Saint Anselm himself, his influences, and the people he influenced, but also on the topics that he was interested in, among them faith and reason and church and state. So I think it fits in very well with the topic for tonight. So I'm delighted to introduce to you our participants. We're delighted to have Dr. Michael Moreland as our speaker this afternoon. The topic for his lecture is the First Amendment and Religious Liberty Today. Dr. Moreland was appointed University Professor of Law and Religion and Director of the Eleanor H. McCullen Center for Law, Religion and Public Policy at Villanova University in 2017. Professor Moreland joined the Villanova faculty in 2006 and served as Vice Dean from 2012 to 2015. His research is primarily in the area of torts, law and religion, bioethics, constitutional law, and he regularly teaches torts, constitutional law, justice and rights, seminars in law and religion, and undergraduate courses in ethics. Professor Moreland received his BA in philosophy from the University of Notre Dame, his MA and PhD in theological ethics from Boston College, and his JD from the University of Michigan Law School. Following law school, Professor Moreland clerked for the Honorable Paul J. Kelly Jr. of the United States Court of Appeals for the 10th Circuit, and was an associate at Williams and Connolly LLP in Washington, D.C., where he represented clients in First Amendment, professional liability, and products liability matters. Before coming to Villanova, he served as Associate Director for Domestic Policy at the White House under George W. Bush, where he worked on a range of legal policy issues, including criminal justice, immigration, civil rights, and liability reform. Today's panel will be moderated by John Greabe at the end there, Professor and Director of University of New Hampshire Franklin Pierce School of Law and Director of the Warren B. Rudman Center for Justice, Leadership, and Public Policy. Professor Greabe specializes in constitutional law, federal courts, and civil rights litigation, and has published papers in a number of well-respected law journals, in addition to writing a monthly column for the Concord Monitor. Additionally, Professor Greabe is admitted to practice before the United States Supreme Court, the United States Courts of Appeals for the 1st, 7th, and 8th District, the United States District Courts for the districts of New Hampshire and Massachusetts, the New Hampshire Supreme Court, and the Massachusetts Supreme Judicial Court. Chief Justice John Broderick, I'm glad to have him here this afternoon, is the former executive director of the Warren B. Rudman Center and former dean of the University of New Hampshire School of Law. Prior to leaving the bench, he was Chief Justice of the New Hampshire Supreme Court since 2004 and served as Associate Justice since 1995. Prior to joining the bench, Chief Justice Broderick was a trial lawyer at the law firm of Devine, Millimet, Stahl, and Branch in Manchester, where he chaired the litigation department. He served as president of the Bar Association and State Trial Lawyer Association, and is a fellow of the American College of Trial Lawyers. In 1989, he began his own firm of Maryland Broderick, specializing in civil trial work. Chief Justice Broderick is a 1969 alumnus of the College of the Holy Cross and received his law degree from the University of Virginia School of Law. Dr. Christopher Galdieri is a professor of politics here at Saint Anselm College. Professor Galdieri teaches a wide range of topics in politics related to American government, including the New Hampshire primary, the presidency, and constitutional law. A frequent commentator on political matters both here in the Granite State and across the nation, Professor Galdieri has made appearances on the Union Leader, WMUR, Boston Globe, and many other venues. He is the author of Stranger in a Strange State, The Politics of Carpetbagging from Robert Kennedy to Scott Brown, and also Donald Trump and the New Hampshire Politics. A native of Scranton, Pennsylvania, Dr. Galdieri received his undergraduate degree from Georgetown University and his doctorate from the University of Minnesota. As we begin our program, please give a warm welcome to our speaker, Dr. Michael Moreland. Here we go. Is that all right?
Thank you, Dr. Brown, for that generous introduction, and to Max and Hannah from the Center for Ethics and Society, and also to the Institute of Politics and to the Saint Anselm Institute. And thanks to all of you for coming here before the gather there's snow on the way tomorrow. I was thinking it's especially fitting to talk about religious freedom at a college named for Saint Anselm, because as some of you probably know, he was Archbishop of Canterbury during what is sometimes called the investiture controversy, about basically the state's authority over the appointment of bishops and the like. And after he died in 1109, some 70 years later or so, his successor as Archbishop of Canterbury, Thomas Becket, was assassinated in 1180 for basically disagreements he had with the king at the time. So it's a fitting topic for our afternoon here. So I'll talk just a little bit about some issues regarding the Establishment Clause in the First Amendment as a way into some broader issues that we can talk about as a panel about the Supreme Court and about changing personnel in the Supreme Court, issues before the court, and the relationship of things like the court's precedent to the original understanding of the Constitution and other issues. So I'll be focusing on the First Amendment here. For our panel discussion, we can open it up. We can talk about whatever interests you with regard to the Supreme Court, which is much in the news these days. So what I thought I would do is focus, though, on some issues regarding the Establishment Clause and the way in which the interpretation of the Establishment Clause has undergone a remarkable change in just the last several years. So begin with the text of the First Amendment. My first assignment in constitutional law is often to have the students read the Constitution. And so the Constitution, the First Amendment, of course, is part of the Bill of Rights that were enacted shortly after the Constitution was ratified. We have a story we tell that the First Amendment is first because it's the most important rights about freedom of speech and religion and the like. Turns out that's not true. It was actually the third of 12 amendments that were submitted to the states as part of the original Bill of Rights. The first two amendments weren't ratified at the time. One was much later. So the First Amendment was actually the third amendment of the original Bill of Rights. But it says, Congress shall make no law, and some people joke they should have just stopped right there, but Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And we've had 2+ centuries of debate about what that provision means, what its significance is. As I said, I'll be focusing on the issue of establishment, but I'm happy to talk about free exercise, which is also a hot topic and has been much in the news the last few years as well. But in the interest of time, I'll focus here primarily on some issues about establishment. So the one thing that people often associate with the Establishment Clause, if you're to interview someone on the street and ask about what does the Establishment Clause say, or what's the First Amendment say, one thing they're likely to invoke is this idea of separation of church and state, which of course isn't in the text of the First Amendment, but is a common way of understanding or framing what the First Amendment means. And the reason for that is primarily actually the original invocation or use of the wall of separation metaphor is due to Roger Williams, associated with Rhode Island, just down the road here, I suppose. But the reason it became especially prominent was that it was invoked in a letter that Thomas Jefferson submitted to the Danbury Baptist Association in 1802, in which he talks about this idea of a wall of separation between church and state. Its contemporary significance is due to a 1947 US Supreme Court case called Everson versus Board of Education. And I'll talk about a lot of these cases. I hope it isn't unduly confusing, but the facts are often interesting and important. Everson was really, in some ways, the first major Establishment Clause case of the modern era. It involved a New Jersey program that allows for busing, using public school busing operations to bus students to all kinds of schools, public schools, of course, but also to religious schools as well. We have a similar program in Pennsylvania. I don't know, does New Hampshire have busing for? Some states do, some states don't. But basically, New Jersey, Pennsylvania, where I live now, are among the states that allow for public school district busing operations to be used to take kids also to religious schools. And so there's a question about, does this violate the Establishment Clause? Is this unconstitutional violation of the Establishment Clause because it's aid to religious education. Basically, the kids would have to walk or drive on their own, but New Jersey said we'll reimburse for the cost of the busing. And in the Everson case, Justice Black, writing for the majority, said two things basically that were significant. One was that the First Amendment's Establishment Clause, and he invokes Jefferson for this point, is meant to erect a wall of separation between church and state. But here he said, well, it's a generally available kind of neutral program. It's sort of like if the church starts on fire, they can call the fire department. That's not an Establishment Clause violation, we presume. So also here, as long as it's kind of a benefit that's provided in a general kind of way that isn't especially trying to favor religion in a particular kind of way, it's constitutionally okay. And so that begins then this modern era in which this wall of separation metaphor, though, is an especially central, prominent way of understanding what the Establishment Clause requires. Fast forward a few years to a case, Lemon versus Kurtzman, decided in 1971. Lemon became famous for reasons I'll talk about in a moment. The case itself involved, it was actually a pair of cases that came up before the court involving Rhode Island and Pennsylvania salary supplements for teachers, basically because religious schools paid less than public schools. What the state programs did in these cases was that they basically gave out a salary supplement so that the religious schools could sort of top up the salaries of their teachers in non-religious subjects, so math, social studies, history, and so forth. Well, the court in Lemon versus Kurtzman says that's unconstitutional. That is a violation of the Establishment Clause. That's aid to religion in contravention of what the Establishment Clause requires. And the court in Lemon versus Kurtzman, an opinion by Chief Justice Berger, set forth this test that was supposed to kind of frame all Establishment Clause questions to come. And the test says that a law has to have a secular purpose, that the primary effect must be neither to advance religion or to inhibit religion, and that the law must result in excessive government entanglement with religion. These are the three parts of the Lemon test. It's what the common law course, up until at least last year, we would have talked about as the kind of framework for understanding what the Establishment Clause requires, that basically the court is supposed to kind of look at this and figure out whether or not a law violates one or more of these restrictions, and if it does, then it's unconstitutional. Later, in a series of cases involving different things, which I'll talk about in a moment, the court kind of tried to re-articulate this under the guise of endorsement, that essentially the court should ask, would a reasonable observer upon coming upon some, say, funding program or whatnot, say, is this an endorsement of religion or not? If it is, if it's government endorsement, that's unconstitutional. If it's not, then it's permissible under the Establishment Clause. Lemon, as again, I have to talk about more in discussion, but it's really kind of the focus of what I want to say here. Lemon itself proved to be, for decades to come, extremely controversial. Why? Because none of the Lemon factors, at least the critics went, none of the Lemon factors or endorsement, none of that's in the First Amendment. The text of the First Amendment doesn't say that. And the critics of Lemon argued it's not what the original understanding of the First Amendment and what establishment of religion, what a prohibition on establishment looked like. That basically the court in 1971 came up with a series of tests that were extra constitutional, non-constitutional, weren't part of the original understanding or text of the Constitution. And as I say, this proved to be tremendously controversial for decades to come. But that didn't stop the Supreme Court from deciding lots of cases involving the Establishment Clause. And here again, I'm just kind of skimming the surface of a lot of issues. But so what kinds of issues came up in this, as I call it, sort of the era of separation, in which the post-Everson wall of separation metaphor was doing a lot of work. Well, there were famously the school prayer cases, like Engel versus Vitale in 1962, which held that a New York state required composed sort of non-sectarian prayer that was composed and recited as part of the public school curriculum. That was unconstitutional. And that was a series of cases, including in 1992, Lee versus Weissman, which was a prayer at a high school graduation. All those school prayer cases, starting with Engel, held that that kind of prayer as part of a school curriculum was a violation of the Establishment Clause. Why? Because it violated this norm or metaphor of separation. Lots of school funding cases. Lemon itself, as I mentioned, involved salary supplements for teachers. Cases like Committee for Public Education versus Nyquist, cases involving the provision of maps, special education teachers, field trips, textbooks, all kinds of cases that came up, and they came to, for complicated reasons, they came to a variety of conclusions. Sometimes the court said that, for instance, the provision of textbooks by the public school district to religious schools, that was constitutionally permissible for math and science and so forth. But the provision of, for instance, special ed teachers in certain kinds of contexts, that was unconstitutional. So a lot of cases involving school funding. Legislative prayer, I separate off here about basically whether or not you can have an invocation or a chaplain lead a prayer at the beginning of a public official legislative session or whatnot. And in a series of cases beginning earlier involving a challenge to Nebraska's having a legislative prayer, but then more recently in 2014 in a case called Town of Greece versus Galloway involving a New York, again, a county council that had a prayer led by a member of the community at the outset. The court said that was okay, that was permissible. Why? Well, Town of Greece versus Galloway says, well, because it's part of the, even going way back to the first Congress hired a chaplain. The United States has long supplied chaplains to the military. And so as a matter of kind of tradition and practice, we don't think that legislative prayer violates the Establishment Clause, but notice, as I said earlier, a school prayer does. And probably the area that a lot of people know most familiar because they hear about these cases in the news are cases involving public displays of religious symbols. Things like nativity scenes in front of courthouses, cases involving the display of the 10 Commandments on public property. And actually on the same day in 2005, right? In 2005, on the same day, the court decided a pair of cases, one involving a display of the 10 Commandments, very big prominent display of the 10 Commandments in front of a courthouse in Kentucky, the other involving display of the 10 Commandments as part of a wide set of other memorials on the grounds of the Texas State Capitol. And on the same day, the court said that the Texas display was constitutionally permissible because it was one of a number of monuments that were sort of honoring Western civilization, broadly speaking, but that the prominent display in front of the Kentucky courthouse was unconstitutional because it was just sort of too much of an endorsement or whatnot. So these are, again, just a very quick snapshot of the wide variety of cases in which the court, often operating in and through those Lemon factors from Lemon versus Kurtzman 1971, tried to figure out what counts as a violation of the Establishment Clause and what doesn't. And it was, to many ears, a very sort of dissatisfying assemblage of cases. I've heard or told that the late Justice Scalia used to ask people who were interviewing with him for a clerkship, what is the most confused area of constitutional law? And of course, many people thought the right answer in Justice Scalia's view would be the 14th Amendment Substantive Due Process Clause because of Roe versus Wade and cases like that. And he said, no, it's the Establishment Clause. It's just a total mess of contrasting precedents that makes no sense. So that is, again, happy to talk more about this later, but that's a kind of a snapshot of some of the cases that arose during this so-called era of separation. But as I mentioned, the Lemon test itself, this way of approaching the Establishment Clause, was subject to widespread criticism. And here I just take a quick snapshot of 3 cases in which that edifice of Lemon began to crumble and eventually fall. The first goes all the way back, and I could even invoke cases earlier than this. But 2002, the court decides in Zellman versus Simmons-Harris, a case involving whether or not the state of Ohio could issue vouchers that then could be used by parents and children in Cleveland to then to use those vouchers to go to private schools, including religious schools. Was that constitutionally permissible? The court, 5-4, in an opinion by Chief Justice Rehnquist in Zellman, says yes, that is constitutionally permissible. And how many times in Zelman versus Simmons Harris does Chief Justice Rehnquist cite the Lemon case? Not once. He doesn't cite it at all. He just sort of sidesteps the question, says that because the independent choice of a parent and children to use the voucher to go to a religious school, that severs the link between the state's funding and the use of the dollars in a religious school. Therefore, it's constitutionally permissible. And he completely sidesteps the question of how this can be squared with Lemon. Fast forward a little bit more recently to 2019, the American Legion case involved, that's the actual cross. It's a war memorial cross erected in Prince George's County, Maryland, to memorialize fallen military heroes from the First World War. The American Humanist Association brings a constitutional challenge to the display of the cross, says that having this kind of cross on public land is a violation of the Establishment Clause. And the court in that case says, no, that because the cross has different kinds of meanings to different kinds of people, here the purpose is not to sort of foster religion, it's more to memorialize people who have died in military service, and because it's over 100 years old or so, that because of all that, there's a kind of almost grandfathering exception to the Establishment Clause, and the long-standing use of crosses and things like military cemeteries and so forth, all that means that this doesn't violate the Establishment Clause. But the court took a sideswipe in the American Legion case at Lemon, saying, Lemon is kind of past its sell-by date, and we really should be revisiting the Establishment Clause in a more wholesale way. But at the time, they weren't ready quite yet to abandon Lemon altogether. And then most recently, last year, in the Kennedy versus Bremerton School District case, that's actually Coach Kennedy there. This was a case, the facts are a little disputed and complicated, but essentially this was a high school assistant football coach who wanted to pray at the 50-yard line after the games were over. And the question, the dispute in the case about, was he on his personal time, was he on school time, and so on. The reason, of course, that the school district said that they had to suspend Coach Kennedy, which they did after he had engaged in this, was because of the Establishment Clause. If we allow Coach Kennedy to do this, it will look like we're endorsing religion. Therefore, we have to, after he refused to stop taking a knee at the 50-yard line and praying, therefore, in the interest of the Establishment Clause, we have to suspend him. In the course, I'm happy to talk more about the Kennedy case and some of the sort of finer points of the issue there. But in the course of deciding the Kennedy case, Justice Gorsuch, for the majority of the court, says along the way, oh, by the way, this court long ago abandoned Lemon and its endorsement test. The era of Lemon that began in 1971, the era of kind of separationism, if you will, that's finished now. Instead, Justice Gorsuch said, in place of Lemon and the endorsement test, this court has instructed that the Establishment Clause must be interpreted by reference to historical practices and understandings. And you see here the kind of argument here about what does the First Amendment mean as a matter of original understanding and historical practice. Not Lemon, that's made up 1970s constitutional doctrine. Instead, we're going to look to what are the historical practices and understandings of the First Amendment. And as I said, it opens up into bigger questions about things like what should the Establishment Clause mean? Should we look to the original understanding as the primary way of understanding what the First Amendment requires? What's the significance of precedent? This obviously was much more of an issue controversially in the Dobbs case in overturning Roe versus Wade. But even in the case of Lemon, Lemon was a 50-year-long precedent. A lot of people thought it was kind of unworkable and didn't make sense at the time and hadn't made much sense since then. But 50 years is a long time for precedent to be established, and that the court shouldn't too cavalierly discard its own precedents. But the majority in the Kennedy case said, you know what, we've long ago abandoned it. See cases like Zelman, others where we didn't use Lemon as the way of understanding the Establishment Clause. Therefore, we're going to move on from it. And as Justice Gorsuch says, we're going to look instead to what are the historical practices and understandings of what constituted an establishment of religion. And that's where we are today. Basically, the question now is what going from here on out, post-Kennedy, what are the kinds of arguments and ways of understanding the Establishment Clause that are in violation of the Establishment Clause as a matter of original understanding and historical practice? And what are the ways of understanding the Establishment Clause that are ahistorical, not part of the original understanding, not part of the text, not part of the structure of the Constitution? And this is a recurring theme in a lot of contemporary Supreme Court doctrine. Just within a few days of the Kennedy case, the court also decided, again, quite controversially, the Bruin case involving a challenge to New York's basically the permitting regime for concealed carry. And there also, the court, in an opinion by Justice Thomas, said, what's the way of understanding the Second Amendment? What are the historical practices and understandings of what kinds of gun regulations are permissible under the Second Amendment and what kinds of regulations fall outside of it? So just as you saw in the case of the Establishment Clause, so also in the case of the Second Amendment, so also in the context of the 14th Amendment, the right to abortion, the court coming to this issue of not so much precedent being at the center of how we think about constitutional issues, but trying to recover instead original understanding and historical practices. So the question, well, then what does violate the Establishment Clause? And here I just borrow from an article from 2003, from 20 some years ago, by Michael McConnell, who now teaches at Stanford, in which he set about to make an argument about, well, what kinds of things were, as a matter of original understanding, thought to be an establishment of religion when the framers of the First Amendment back in 1790, and the ratifiers of the First Amendment back in 1791, what would have been their understanding of what counts as an establishment of religion? And here I just borrow from McConnell saying, well, things like control over doctrine, governance, and personnel of a church. So we have constitutional decisions about, for example, the immunity of churches and other kinds of religious institutions from interference in their personnel matters. Compulsory church attendance is another example of an establishment. Financial support in the form of religious taxes to actually support churches or to pay clergy, which is not unknown in Europe, but he says that was something that the Establishment Clause was meant to forestall or prohibit. Prohibitions on worships in dissenting churches, of course, much of again, something not unknown in modern Europe and English history. Use of church institutions for public functions, and restriction of political participation to members of the established church. He says these are the marks of of an establishment. And when the First Amendment says no law shall be passed by Congress respecting an establishment of religion, these are the kinds of things that the framers of the First Amendment would have understood. Notice, of course, there that it means that the line of cases from Everson on that were worried about public displays of religious symbols, indirect funding of religious institutions, legislative prayer, case like that, none of those run afoul of, at least in McConnell's view, of what the original understanding of the First Amendment would have thought counts as an establishment of religion. So as I say, this is a very quick, I appreciate, snapshot of the Establishment Clause and how it has undergone a dramatic, over the course of the last 50 years, 70, 80 years, dramatic set of reinterpretations, but also I think opens up into bigger questions about how should we interpret the Constitution, changes on the court's personnel, different kinds of political valences to the Establishment Clause, although as a way of illustrating the point that, as Justice Gorsuch said in the Coach Kennedy case, that the era of Lemon and of its test has now come to an end. Thank you.
Thank you very much, Professor Moreland. That was really interesting. And let me start by thanking you all for welcoming me here today. I want to sort of use your talk as a jumping off point. As you have just described so clearly for us, the notion of the Establishment Clause as an individual right to be free from religion, that idea is shrinking. Yeah, this idea that the Establishment Clause creates an individual right of one to be free from religion, that is changing. Correspondingly, I think if you'd had a little more time, you would have talked about how the free exercise right, also in the First Amendment, is an individual right that seems to be expanding. So these are two important areas of the law that people care about that are undergoing some rapid change. And it's not just in the First Amendment that Supreme Court doctrine is undergoing rapid change right now. And a lot of that is, I think, because, as you say, the move has been away from focusing too much on constitutional precedent in favor of this textualist, originalist understanding of the Constitution, which has been translated into a historical approach. One consequence of that is that people who don't like this new direction are, engaging with the court and frustrated with the court. So there are public opinion polls showing that the court's reputation, if you will, is diminishing right now. And there's been a lot of criticism of the court because it's changing things so fast that it's reinforcing the notion that what happens in our most divisive constitutional cases isn't really law. Rather, it's really power. It's partisan politics in action in another forum. So you will hear that I would submit, I think you hear that criticism about this court a bit more than was previously the case. And I wanted to start today by going down the panel and asking first if you think that criticism is warranted, if you have some concerns about the way in which the court is functioning presently as an institution. And then secondly, if you do think that there is some merit to those criticisms, what might the court do about it? What might Congress do about it? What might some of the solutions be? Why don't we go right down the aisle this way and start with Justice Broderick, my former boss.
At least we start with easy questions, right?
Right.
Yes, I am concerned about the image of the Supreme Court of the United States, and I say that with a lot of respect. And I don't blame the court entirely for that, although they own some of it. I also blame the process that brings justices to the court, which has become so overtly political. I mean, most of the hearings that are held down in the Senate, doesn't matter if it's a Republican or Democrat, most of the senators know before they begin that they're not going to win or they are going to win. It's pretty well known. And so what they do, a lot of them, is ask questions that they know they're not going to get answers to, or at least they're not going to think they will get satisfactory answers. And then they raise money off of that during the hearings. I mean, I think that's disgraceful. The first televised hearing, by the way, of a Supreme Court justice was Justice O'Connor in 1980, I believe. And that was pretty tame, and she got like 97 votes from the Senate. Those days are over. So by the time justices are confirmed, if they are so tarnished in the public mindset that when they take the bench, it's hard to leave that behind. From the court's perspective, I think the judges are not helping themselves. That is to say, and on that point, by the way, I just want to hold up Justice Souter from New Hampshire as a gold standard in my mind. Justice Souter kept to himself. He was known through his writings and his thoughtful opinions and dissents, and that's about it. He wasn't writing books. He wasn't appearing in public places. He wasn't appearing before people who had agendas and rallying the troops. He understood what it was to be a justice of the United States Supreme Court. And the other thing he did, by the way, he didn't treat it as a death sentence. Most of these people die there. What is that? Justice Souter served 19 years from age 50 to age 69, and then he came home. And when he came home, he started sitting again on the First Circuit in Massachusetts. He's kept a very low profile. That is the model, in my mind, of what a Supreme Court justice should be. And that's not even a partisan statement because it happens on both sides of that aisle. The last thing I want to say, having served for 15 years on a court, I was bound by a rule of ethics. I knew what they were. I knew they had teeth. And we did all we could to abide by them. Supreme Court of the United States, on that front, is accountable only to God. That's a problem in 2023. If every judge in America is bound by a code of conduct, professional conduct, rules of conduct, ethical rules, it's not that the Supreme Court is oblivious to them. I'm not saying that. And do they consult them? Sure they do. Do they consult other sources? Yes, they do. Are they bound by any of those? No, they're not. I think that's troubling. The last thing I do want to say is that, as Professor Greabe said, that the standing of the Supreme Court among the American public is down considerably. That's very concerning. It's supposed to be the non-political branch of government, and it's not living up to that. Again, not all their fault. But what's most disturbing, if you look at the polls right now, for example, more Republicans have faith and confidence in the court than Democrats. It's not a fault of Republicans. It's just the way we are in America. And the more divided and partisan we are, the more the political process that puts these people on the court seems more partisan and political. Why would we respect the results? And that is a genuine concern that all of us should have, because once the Supreme Court of the United States, which has no real power other than its integrity, once that starts to wane, all of us are affected by it, whether we know it or not. And it may well affect the people willing to serve on that court in the future. That concerns me too. That's a long answer to your question, but that's how I feel.
There's a lot of meat in there. Thank you. Thank you. Professor Galdieri.
Yeah, I generally agree. I think you bring up the point about it feeling like raw power. And I think for the court, a lot of what we've seen over the last 7 or 8 years has been that, not from the court itself necessarily, but from the folks trying to put people on the court. The blockading of Merrick Garland's nomination in 2016 using a standard that had never existed prior to 2016. And then in 2020, okay, we have a vacancy that came up, what was it, 6 weeks before the election? Let's fill it right now before the election. And so if you're someone from outside watching that, it really does seem like, the judicial equivalent of Calvin ball. It's like whatever rules anybody can use to get somebody on, we're going to do that. And I think that necessarily makes the court look incredibly political. I also think you've got the fact that the justices treat it, as you said, like a death sentence in most cases, raises the stakes incredibly, because you're not talking about somebody being on the court for 10 or 15 or 20 years. I figured out the actuarial tables for the court. And if Amy Coney Barrett serves for as long as John Paul Stevens did, she will still be on the court in the 2060s. Yeah. We're dealing, suddenly it's gone from this thing somebody does for a respectable period of time to just this literal lifetime commitment and a lifetime opportunity to exercise power. And what's especially concerning is the court is fundamentally not democratically accountable, small d democratically accountable to anybody. They issue their decisions and people generally respect them. We haven't seen a president say in quite a while, well, the court has made their ruling, let them enforce it. So again, the stakes become incredible. So every vacancy is incredibly high stakes. If you replace Scalia with Garland, that has implications into the 2040s, as opposed to for the next 5 or 10 years. And so it's become this just magnet of this locus of pure power, simply because that's what it's become. And I think it raises really troubling questions, particularly because they're not elected, and many of the recent justices have been appointed by presidents who didn't win the popular vote. So that raises further questions. And I think at a moment where the court should probably be acting pretty modestly, there were certainly decisions they could have handed down in Dobbs consistent with all the justice preferences that didn't actually strike down Roe, for instance. Instead, you're seeing this power being used really, really expansively. And I think that's a recipe for, at some point, the dam is going to break and somebody's going to say, okay, sure, you did this, but everybody's going to ignore it. And that's not a great place to be.
Thank you. Professor Moreland.
I think these issues, they come and go. Obviously, there have been other eras in which the court was very controversial, and then the national mood kind of was tempered somewhat. I think one thing that is in some ways, it's not the court's fault at all, but the court decides a lot of cases. They say about 70 or so a year. A lot of cases are decided 9-0 or 8-1. This morning they handed down three cases, I think, and two of them, as I recall, looking on my iPhone, were unanimous or nearly so. But it's the high-profile cases where the court's divided 5-4 or 6-3 on very flashpoint issues that I think get a lot of attention, understandably. But it's also important to know that for a lot of the court's docket, they're deciding cases in ways that really don't have much of a political valence, and they're really just doing law. I think it's good that a lot of the justices, and they're speaking over the last year or two, including Justice Breyer on the more progressive end of the court, or Justice Barrett on the more conservative end, have talked about that it's bad to politicize the court. It's bad that the court is seen as just another set of political actors. I think that's valuable as well. And I guess the last thing I'll say is that it does strike me that a lot of the current debate, or the current crisis, maybe is overstating it, is about abortion, is about Dobbs and the decision to reverse Roe versus Wade. But my one 30-second footnote on that would be, unlike in prior eras of the court, for instance, in the New Deal crisis in 1937, where the court was blocking Congress from enacting New Deal legislation through the democratic process, and the court was striking down some of that legislation. In Dobbs, at least, the merit of that, I understand this is a highly contested question, is that it returns to the political process an issue that in 1973 the court had taken out of the political process and arrogated to itself. And so from that standpoint, I think that, and we saw it last year in the elections, we saw that, we'll see where the chips fall with regard to that particular issue. But I think that a lot of the polling and other kinds of tumult around this right now is driven by that one issue.
Thank you. Just to add one quick thought, one norm that changed over the last several years was that it became common, at least for one president, to start to refer to judges and justices as Obama justices or Trump judges, for example. I would just add that is not helpful. That is not a helpful development in terms of promoting the idea of the court as a place where law happens, again, rather than our partisan politics. So one of the topics that was on the agenda to talk about today was the court's involvement in political matters. A huge case was taken by the court this year involving a doctrine that's become known as the independent state legislature doctrine. Looks like that case is actually likely to go away as moot, but the issue is still there. What do you think about the court being involved in cases that are so directly connected to our politics? You go back, one of the major decisions of the Warren Court era, of the civil rights era, was Baker versus Carr, which was really the court's first foray into deciding questions that had a really direct impact on our political process. And Justice Frankfurter in that case wrote an impassioned dissent saying, this is a huge mistake. The court should stay absolutely away from that. Sure enough, the court has traveled down that path, and there are a lot of people who are concerned about that today. And I wonder whether our panelists share those concerns.
No, I think it's a genuine concern. I do think that, just from my own experience, when I was on our court in Massachusetts Supreme Judicial Court, I think on a 5-4 vote or 4-3, whatever it was, they decided that in the Goodrich case, that gay marriage was a constitutional right under the Massachusetts Constitution. And so when that came down, which caused a firestorm at the time, I thought, well, that'll be coming to our court here in New Hampshire. So the Massachusetts legislature had ducked that. Legislatures are good at that, by the way, ducking the tough problem. And so in New Hampshire, I thought, well, they'll duck that problem and we'll have it. They didn't. It was a political issue. They resolved it, and they supported a right to same-sex marriage. We didn't have to deal with that. At the time that was going on, when I was on the Supreme Court, I would go to the Chief Justice's meetings around the country, people who had my job in state courts. And I was talking to the Chief Justice of Iowa, who was a really bright, really lovely person, and they had a case like that. And she said to me, I'm going to lose my job. I said, you're going to lose your job? Yeah, she said, we're voted out here. People vote for us or against us. We come up for elections, which is foreign to us in New Hampshire. We're appointed till age 70. Anyway, I said, oh, that's not going to happen. Don't be silly. She said, well, we wrote a really detailed opinion trying to explain that we're not against religion. We try to explain the Constitution and the history. When the election came around, 3 of those folks, she was one of them, were voted out. Because whatever they decided was not popular. And part of the challenge, as someone who did this job for 15 years, I took an oath not to be a politician, not to be popular, but to try to figure out what the answer was. And I think what's happening today, particularly when you drag the political process behind the bench in a professional way, I don't mean a personal way, people lose respect for it. Judging is seen as a different form of politics. Dangerous, dangerous. When I was your age, that was 100 years ago, I knew who the Chief Justice of the Supreme Court was. I might have known the names of a few justices. I didn't know anything about them. Now I know where they live, what books they read, what books they're writing, where they're appearing. I hear their speeches. What is that? We have celebritized the Supreme Court of the United States. And so it doesn't seem partisan. I was watching the Kennedy Honors one night, the Kennedy Center in Washington, and out from behind the drapes came a face that I knew, but this face was all dressed up in a way that I wasn't used to seeing them. And this person went to the podium, the place was packed, and the honorees were in the balcony, and she was there to introduce the honoree. And it was Justice Sotomayor. I thought, what are you doing there? That's not your role. If you want to be a celebrity, you should be a celebrity. But if you want to be on the Supreme Court of the United States, you shouldn't be out here doing this. When I see justices of the Supreme Court on commercial television, I don't even care if what they say is appropriate. Years ago, I'd see them on the Jay Leno show or the Tonight Show promoting a book. What is that? That's not their role. I would never have done that when I was on the state Supreme Court. It just seemed wrong to me. And so this celebrity Supreme Court we have, and we play into it, the press plays into it. I loved Ruth Bader Ginsburg. She became a celebrity. And I don't think that's healthy or helpful for the Supreme Court of the United States. I want to know that they're honorable and decent and hardworking. I don't want to know what they have for breakfast. I don't want to know what movies they see. I just don't, because I can't do anything about it anyway. And so I think the more we start to identify these people as individual celebrities, it's harmful for the administration of justice. It's not the Supreme Court. It's Justice Gorsuch or Justice Breyer in the former court or the new Justice Brown. I think we know more than we need to know, and that is celebrated. Doesn't mean they don't have integrity. I'm not saying that. But we have celebritized that body. And it's lost something in the translation, in my view.
A couple things. On that front, I do tend to agree, but I also think when we're in an era where you get more firsts, more diverse people being appointed to the court, it's more newsworthy. So I think people are just more aware of a Ruth Bader Ginsburg or a Ketanji Brown Jackson. I almost said Jackson Brown, who's someone entirely different, than they would have been back in, the 1950s when it was just, a bunch of Protestant white guys on the court. So I think that probably means there's more public interest, but I do think there's something to that. In terms of the court being, involved with elections and that sort of thing, I'm struck by how election Twitter last night was consumed with the primary for Wisconsin Supreme Court, because it's generally understood that the winner of the general election in, I think, April, is going to determine the course of that court's future for the next few years, and could have a huge impact on Wisconsin politics. And again, that's a judge being elected. In other election cases, understand courts' reluctance, but sometimes something occurs. I think a Supreme Court, given Bush v. Gore, really has no choice but to rule on it. On the other hand, all through 2021 and 2022, we saw redistricting cases, one after another, going to the Supreme Court. And there didn't seem to be much rhyme or reason as to what decisions were coming down. It just seemed to be, well, it's too close to the election for this map to go through. It's not close enough. This one gets to be redrawn. And that was it. And often these were not given with a ton of explanation of the reasoning or anything, or any doctrine that could be followed or relied on for future appeals. And again, given how much we know that redistricting can affect the future of elections, it's just a really troubling place to be. Like the fact that New York was held to one standard, but Florida was not, and so on. Arguably decided which party wound up controlling the House. That's weird.
Yeah. Thank you.
Well, just a couple thoughts, I guess. The issue of state judiciaries that has sort of been put on the table is an interesting one. It's obviously a field from our topic of the U.S. Supreme Court. Actually, in Pennsylvania, some of you may know, our judges are elected on a partisan ballot. They're endorsed by the parties and then are elected. So, but I know a couple people on the Pennsylvania Supreme Court. I've talked to them a little bit about it, and they say, well, obviously there are goods and bads about it, but you're out with the voters, right? If you're elected, it means you're accountable to the voters in an important sense. But the federal judiciary in many states, is Justice McCormick was saying, go a different direction. And I guess on the election stuff, as Chris said, I mean, there's they sort of don't have a choice, right? There are things like the Voting Rights Act and redistricting decisions and issues about the independent state legislature doctrine that's now pending before the court, where the court does have to rule on those issues and has those topics have been around for or at least some issues of all the elections have been around for a long time. And so in that sense, there's a kind of inevitability to the court's involvement, at least in those aspects of the political process. But so far as possible, I think it's imperative, and people's views will differ on how successful they've been, that they not appear to be acting for kind of purely partisan gain.
I just want to make a comment. When part of the problem on contentious issues that we were talking about, when they go to the Supreme Court of the United States, and the public views those issues through a political lens, more often than not, the result is as you expected it would be from the people you expected would rule that way. And so that plays into this notion that it is all politics. For example, in the Dobbs case, the Chief Justice would have upheld a 15-week ban. That's what he wanted to do. He wouldn't have overturned Roe v. Wade, but he would have held it to 15 weeks. And his colleagues didn't feel that way, and he lost that. As an institution of government, the Chief Justice's role, I think, had it been followed by his colleagues, would have given the public writ large greater confidence. When the Obamacare mandate was before the Supreme Court, and the Chief Justice said, well, maybe they can't do that, but we'll treat it like a tax. So we're not going to throw the whole thing out. That shocked people. And they said, well, maybe it isn't all about politics. But when it seems to be all about politics, it's pretty hard to say it's not all about politics. And the other thing I would note, and I think it's gotten worse over time, and the Dobbs case is a good example. I think 15 different justices had looked at the abortion issue at the Supreme Court level since Roe and Casey. And it wasn't unanimous in those cases, but it was consistently affirmed. And then when the opinion was written in Dobbs, it was pretty arrogant, whatever you think of the result. Basically, these people didn't know what they were doing. The arrogance of saying that. There were 15 members of the Supreme Court of the United States over 30 plus years who had said, no, we think that's the way it is. And one of the reasons they overthrew it, it was just wrongly decided. Okay, there's a way to say that without saying it quite as aggressively as that. I think the court's language is coarser than it needs to be. I mean, people are so sensitive to what's going on there. I think the judges need to elevate their game, even if they don't change their opinions. It's supposed to be above that. And I mean, I served as a judge in this state on the appellate court for 15 years. I didn't always agree with my colleagues, by the way. That would have been amazing had I done that. But I don't remember dissenting in any case or writing a majority where others were dissenting, where I attacked the people that I work with. I can disagree with what they think, but I didn't try to belittle them. And you read some of the language in Supreme Court opinions, and you would think, do these people ever have dinner together? What is going on here? There's an incivility that's crept into those opinions over time. And it's 9 chambers, which it has to be. But it doesn't mean they can't have a more collaborative sense of the public. And I think that's harmful to the court. I've always thought that. There's a way to disagree without being disagreeable. And when you change a precedent, as they did in Dobbs, whatever your view is, that precedent protected 51% of the American population, women. And if you're going to change that after 50 years, 49 years, it takes a certain arrogance to say, this was so badly decided, it's unworkable. You can disagree with it, you can change it, but it's pretty dismissive, I think, of the rights of women in this country. That's not to say they don't have a right to do that or that they're not right. I'm not saying that. But I'm saying when you overturn precedent that's been there for 49 years, reviewed by 15 members of the Supreme Court, you better do it with some tact. And I don't think that happened. And then, as we know, the case was released somehow. We all knew what the answer was, right, before it was released. That never happened on my court. That happens in Washington, that happens in politics. Never happened in my knowledge to the Supreme Court of the United States. And then they were going to get to the bottom of it. Did they? Did they? It doesn't instill public trust and confidence, it seems to me. The Supreme Court of the United States is fundamentally critical to American life. The people who put them there are politicizing it to the extreme, and the people who are sitting there, many of them, are insensitive to the fact that they're perceived as politicians. And they need to back up on that. They don't have to change their views, I'm not saying that. But they need to be more sensitive about where they express them and how they express them, both orally and in writing. Sometimes it's like watching a family fight. It's just not fun to watch. It's not. And it's not necessary. And the culture has apparently changed, so we accept that. I've never accepted that. And I don't think the American people should. And if I were on the Supreme Court of the United States, I would say, what are we doing to each other? Disagree with me if you want, but don't belittle me. It doesn't help anybody. It certainly doesn't help the advance of the law in the United States. Other than that, I have no strong feelings.
I could go on. I have so many things I'd like to ask the panel. It's very, very interesting, but I would be selfish if I were doing that. It's time to open the floor to questions. And I think we'd really like to start by hearing from some students. If you have any questions or comments you'd like to share. I understand, yeah, people be bringing microphones around. So any of the students here have any questions or comments for the panel?
So a lot of our conversation is really talking about the politicization of the Supreme Court and kind of the politicization of, making policy. So how can we as students better educate ourselves on policy issues? If we're consuming media that's biased, what are the sources that we should be looking for? What is our duty to understand what's going on in law?
Take take good classes, right?
Yeah. Professor Lucas's public policy class, I think, is the best place to start.
And on this issue in particular, I do think, you know, rather than getting it all refracted through your favorite media source, whether, you know, on the left or the right, but actually, you know, a lot of the opinions are, not all of them, some of them are kind of technical, but, you know, read the opinions of the court itself. You go to SCOTUS blog or other kinds of reputable sources and the Supreme Court's website itself. I often find that students find listening to oral arguments interesting because especially in some of these high profile cases, you hear the justices themselves kind of grappling with these questions and with the very skilled advocates that often appear before them. But, you know, trying to, you know, especially on major constitutional questions, they're not technical in a certain sense, but read them and kind of make your own judgment.
I'd like to second SCOTUS blog is a tremendous resource for people who are interested in the Supreme Court. It's a blog site where you can get any of the briefs, not just the parties' briefs, the amicus briefs that are filed in the case. And when decisions are handed down, they regularly invite commentators from across the ideological spectrum to write up what they call symposia. It's a wonderful resource, and I think I think they really do a pretty good job of avoiding slant, in my experience.
Yeah, and I think also seek out the really smart, really good Supreme Court reporters. I'll put in a plug for Dahlia Lithwick at Slate, who is very smart, is wired in, knows what's going on the court, brings perspective to it. There's also a blog, Amicus, that gets into, sorry, not blog, podcast. Podcasts are blogs, but people say them. If you were over 40, you could laugh at that. But you know, there's good stuff out there, but you need to be a skeptical consumer. You know, you need to you know, not just go for the dopamine hit of somebody who tells you exactly what you want to hear. You want to, you know, read lots of stuff from lots of different people and ultimately figure out for yourself.
Questions?
To bring it back to, we're talking about the religious liberty aspect and the way that the court is deciding on that. How much do you think the recent accepting of more religious Supreme Court justices like Amy Coney Barrett, because it took until you know, Roger Taney to be the first Catholic on the court, and there was still, you know, lots of prejudice there. And you had, you know, in Dianne Feinstein's questioning of Amy Coney Barrett, asking how much she would let her religious beliefs dictate her judicial opinions. How much do you think the accepting of more religious people onto the court has influenced the lessening of religious restrictions?
I mean, I guess I wouldn't, I don't think it's a direct correlation at all. I mean, I think that I was actually at that, Justice Barrett was a friend, and I was actually at that hearing when Senator Feinstein said that about, that was when she was being nominated to the circuit court. So I remember it well. But I don't think it's a one-to-one correlation. I mean, I think that even justices over the time of the court who, you know, may have been less conventionally religious still have had strong views about religious freedom in certain contexts. And I don't think it maps. I think right now it's become, for all the reasons we've been talking about, it's become kind of highly politicized, but at least historically, if you go back 50 or 60 years, actually the strongest defenders of free exercise, right, I should say the justices who were most associated with the strong reading of free exercise often tended to be the more progressive members. Justice Brennan, for example, had a very kind of strong view about the importance of free exercise, and a case called Sherbert versus Verner really kind of ushered in an era of understanding free exercise in a very robust way. And he, of course, is conventionally viewed as a quite liberal justice. So.
You had your hand up before. Would you like to ask a question?
It was mentioned before that these members of the Supreme Court kind of stay on till they die pretty much. Do you think there'll ever be anything passed where it'll limit the amount of years that they're allowed to stay, or the age restriction that these members can have?
let me try that. I don't know whether that will happen. I think it should be considered. It may help depoliticize the process. What I've always found ironic, in virtually every state court in America, New Hampshire being one, you could have been in the world's best physical shape. You had to step down at 70. That's like teenage years on the U.S. Supreme Court. It really is. And that doesn't mean they're not competent or capable, but I think, as was said earlier by the professor, when you look at the longevity of these folks, it makes the political battle on the front end all that much fiercer. I think if people had a 15-year term or an 18-year term, that makes more sense to me than expanding the size of the Supreme Court of the United States. There's been different sizes, by the way. It's not in the Constitution, so it could be changed. But I think expanding it for the reasons that they would be expanding it would really denigrate the value of the court. But limiting your term, I think makes sense. I think it's going to be a tough slog because if you're successful, you want your people there forever. But I think the American people would be served better by that, to be honest.
And just a footnote, it's not clear that Congress by statute could impose a term limit or mandatory retirement. It may require constitutional amendment, which of course is famously difficult to do. Congress could expand the size of the Supreme Court, and that's been an issue that's been so-called packing of the Supreme Court that's been bandied about the last few years. And
Yeah, and to do it by statute would involve a very creative interpretation of the words good behavior, basically saying, well, if you show up for work on year 18 plus 1, or the day after you've been on for 18 years, you're no longer on good behavior and you have to go be a district court judge in Montana now or something. But that it would be tough. I think it's like with the Electoral College. It's like, as long as the elections keep breaking for one party, you don't have the political will to do anything about it. Right now you have conservative courts, so why would Republicans want to limit those justices' tenures? And if the worm ever turns and you get a liberal court, well, then Democrats would discover their love of life tenure. So how do you get there to be very sensible 18-year terms staggered to the first and third years of presidential terms? That would lower the temperature, lower the stakes, and probably make everything a lot calmer.
And consider the optics of who would ultimately decide whether a statute would be constitutional. Right? The Supreme Court, right? So, anyone else? I didn't mean to limit it all to students.
Because one of the things, thank you. One of the thoughts on my mind as we sit here and we're talking about religion and such is the anti-higher education talking right now about how it's being, so liberal and conservatives don't like higher education anymore. I'm exaggerating, but just trying to make a point. So my question is, do you think there will be a swing back where more people respect our educational system as truth, as opposed to liberal ideology?
Sure, I'll take this one. All I can really say is that apparently one of my courses helped inspire Caroline Leavitt to go into politics, which I think makes me the worst liberal indoctrinator who has ever walked the face of the earth.
So my question is, can today's Supreme Court justices, are they capable of considering legal issues without seeing them as political issues?
I couldn't hear that question.
Oh, are today's Supreme Court justices capable of seeing the issues before them as legal and not political questions?
Are they capable of doing that? Certainly. Sure. I don't know, but the problem with the court, as I see it, is not capacity. I mean, they're brilliant people, and I have great respect for them. And I'm not serving in the role they're serving in. All I was trying to indicate is that they need to be extraordinarily sensitive in a world that has become so partisan, to stand back from the campfire so that they don't get caught up in the flame. And that's what I'm most worried about. And celebritizing the court is dangerous. Now, they're not solely responsible, but they have a lot more control over that than they are exercising, in my view. I think their job requires them to disappear some, not to disappear entirely, but I think they need to stand back and be less visible in a political way. I mean, to give you an example, and I'm not picking on the side that won or lost. That's not my point. But when Justice Alito spoke after the Dobbs case, I think to the Federalist Society, he was very upfront about that case, and if it upset people, that's their problem. I mean, it was just so insensitive. That's what I'm talking about. He doesn't have to change his mind. Who would I be to tell him that? But he needs to be sensitive to how it's received, because ultimately it damages the court. So they have capacity to do everything they need to do. They just need to reflect on how they're doing it. That's what I have a concern about. And as a former judge and someone who's been in the law my entire life, I'm concerned about that. Not going to change my life, but it's going to make the court perceived differently. And it should be able to weather the storm through hard decisions. But the more political it comes, and you look at the divide now between the two parties, how they view the court, that's dangerous for American justice, I think. So don't change your mind, but change the way you are serving there so that I know you're there, I respect that you're there, but I don't need to know on a micro level what you're thinking. I think it's problematic. I really do.
I think that, as I mentioned, I think we do the court a little bit of a disservice by focusing on the very high salience political issues that the court sometimes has to handle, because for a lot of cases, they're just lawyers, right? There's lawyers, deciding lawyerly technical cases. And as I said, they often decide those unanimously or nearly unanimously. And I even across the spectrum, I guess I maybe disagree with the justice a little bit. I think that, well, I'll just say it. I think, for instance, Dobbs, I think is, not only do I think is rightly decided, but there's a kind of modesty in returning to the political process this issue that the court had decided in 1973. The court had set itself up as a kind of national abortion regulation board, and that by returning that issue to the political process, I think Justice Alito's opinion, says, look, this is not in the Constitution. It's not as a matter of original understanding, part of the 14th Amendment. And Roe took that issue away from the people and the voters, and now we're returning that issue to the people and the voters in the states, and they'll do what, or Congress potentially could act. And so in that respect, I think that even that issue, which is so controversial, so highly politicized, so divisive over decades and decades of American life, I think that in a way, we'll see, check back with me in 10 or 20 years, I think Dobbs, is in that respect, is an opinion of modesty by returning to the political process, political issues that should be there.
I understand that we've come to the end of our time. This has been fascinating and a rewarding discussion. Thank you so much to our panelists, and thanks to all of you.